All right. Any other administrivia? Very good. So we are coming to the end of defenses, and we're coming to the end of the defenses with arguably, if it weren't, it would be the most important case in contract law if it weren't dependent on the other and worst case, which is Hill versus Gateway, which is probably the worst and most important case in contract law. But we ended with AT&T Mobility versus Concepcion. The basic idea is this, that the Federal Arbitration Act requires states to treat arbitration equal to cases brought in the state courts. There were two questions of what equal meant in the Federal Arbitration Act. The first was that advanced by California saying, hey, we treat class action waivers as unconscionable, and therefore we're going to treat class arbitration waivers as not acceptable under California law. That's treating everybody equally. Justice Scalia and the court disagree. They say that the value of arbitration is its speed and efficiency. That is obviously not true as a market matter. If it were true, consumers, of course, would jump at the chance to spend less and get the same results as they would if they were to go to court. So it's nonsense. But on top of that idea then that people would opt into arbitration because it is preferred by the market was demonstrated to be false by the aftermath, in which we had some of these fairly hilarious test cases where traditionally plaintiffs' firms, but they just rounded up a lot of people who had arbitral claims and said, okay, well, we'll just arbitrate one by one by one by one by one. And the companies were like, no, we actually didn't mean that. Like, not like that. Don't do that. We didn't mean arbitrate when we forced you into arbitration. We meant something different. And that's where we are now. What's interesting, what I want you to do, though, is take stock for a minute, and then I'll take questions that you have about anything in the class. But I do want you to take stock on the evolution of the law. Sometimes we see these early cases that come in a unit as being sort of old common law, old English common law, and then we see how that develops. What we're looking at here is how the law has developed during our lifetimes and how contract law has fundamentally changed during our lifetimes, from the law of voluntary bargain for exchange to the law of forced economic extraction. And I think it's really interesting to look at scholars like Shoshana Zuboff's book, Age of Surveillance Capitalism, in which she says, essentially, it's time to stop calling what we're looking at here contracts. They're not. They're uncontracts. They're the opposite of contracts. They're the photo negative of a contract. If a contract is entered into voluntarily, these are things you have no choice. Go ahead. Say you don't agree to a contract that governs your fully bought and paid for smartphone or car or whatever, right? It just bricks the thing that you fully bought and paid for. You do have no choice here. The idea of choice is nonsense in this framework. The idea of bargaining is nonsense in this framework. When's the last time you bargained for an exchange using the options that Amazon gives you to bargain with them? Hell, even the idea that a court will enforce it, I think we've now seen is nonsense. A court will not enforce almost every contract, quote unquote, that you enter into. And these are all of the contracts that you're going to enter into. This kind of contract has almost completely taken over from the other kind of contract, from the sort of black letter, negotiated out, Arnold Palmer, Empro style, let's talk about it. Each side adds terms that they want in the deal, and then we both sign off on it. That is now sort of a fiction, right? It's not how contracting in raw numbers of contracts happen at all. It still does happen between well-negotiated firms, usually companies, negotiate like that. And every once in a while, you see somebody who's got the market pull to do it. My kid brother, when he was negotiating, working and building some other companies, because he used to work at Waymo, which was spun off of Google. He actually had the market authority. He's like, look, I want to go build something else, and Google was like, okay, we're listening, which is not a sentence that Google says when you say you want to build other products. But by and large, this is not how humans interact with contract law now. Humans interact with the opposite of contract law, with a series of mandatory provisions that are handed to them without choice, that extract the maximum amount of consumer surplus from them, and that's going to be my last point, and are not enforceable in a court because the court is simply going to kick it to an arbitrator. The last point there is also remember our economic basis for the course and why we protect bargain for exchange at all. And you have to do a lot of mental gymnastics to get there with Shoshana Zuboff's uncontracts. Because when you look at them, it's very rough. Oh, I don't know if anybody, just as an aside, I don't know if anybody's spent serious time on Reddit over the past week. If you have, they actually had a link through to the videos of the capuchin monkey experiments that we were talking about. Like, you can watch the capuchin monkey, like, who's perfectly happy doing this for cucumbers. And then when he sees the person next to him when he sees the monkey next to him get grapes, there's this very, very human reaction. Like, he goes in the corner, like completely pitches a fit, sulks, pouts, goes on strike, right? All the things that you might expect. And we talked about why the bargain for theory of exchange is really important to contract law. The idea that both parties are getting something out of it really gives a lot of wind underneath the court's wings to enforce these private universes of law that the court might not otherwise have a real, like, why would we do this? But if both parties are going to be better off and have agreed they're going to be better off, well then, yeah, like, that gives the court a lot of impetus to do this. And I think that intuition too has been reversed with these uncontracts. When you're entering into a contract with one of these entities, you are playing economic poker with someone who can see your cards, because they know how much you're going to pay at what time of day and under what circumstances. That's what the bulk of an entire generation of computer scientists spent doing. That's what AI actually means. Machine learning has been going on for the better part of the past 2 decades, and its task has been to find out exactly under what circumstances you will pay all you can pay, right? You will pay all you can pay under this, and that's full extraction of consumer surplus. And so really this uncontracting move then has undermined the very fundamental reason why we even should take contract law seriously. And historically speaking, we can note this in another way. Contract law is the youngest of the disciplines. We talked about this. Of the classes that you're going to take in your first year, contract law is the newcomer. Property law is the oldest, right? That's the one that's been there since the Romans, and well before. But contract law, this idea that people work together because of a consensual agreement that they both sign on to, like, that is not how society has worked for a very long time. If you go look at England, right, people worked for each other because one person was the knight and the other person was a serf, and one person's got a sword and the other person's got a hoe, and they look at each other, and then the guy with the hoe is like, okay, I'm going to do what you say. That's how that worked out. And that's how that's worked out largely across a lot of human history. That is, we have focused on status and hierarchy as the way of organizing human affairs. And that was often really bad for the person at the bottom of the hierarchy, and it was fairly extractive for the person at the top of the hierarchy. Contract law was supposed to do this move, and we talked about it earlier in the class, but I'm now bookending where we are because we're about to leave our defenses behind and move into remedies. And contract law moved us, or was supposed to move us, from status to contract. If you go look, there are a lot of law review articles out there that will use that language, from status to contract, that we organize our society, or theoretically organize it, along principles of consent and mutual benefit in order to enforce why people work for each other. And so we've replaced the sort of enfeoffment of the feudal system. We've replaced that feudal mode with an employment contract, right, for example. And that's why we work together here. And though what people have begun to notice is that we are now returning to the feudal mode. Because if you go and do a search for from status to contract, the next line you will get in the Google search is all of the articles saying we have now moved from contract to status, right? It's now no longer the serf working on the farm. Instead, we are the product. We are the field that is being mined for data in order to extract consumer surplus. And so we've we've kind of come full circle. We had this sort of period of a couple hundred years where, at least theoretically in the courts, humans worked together based on a consensual agreement that benefited both sides. And now it seems less and less likely that that's the case. All right. So that's just a broad theory level look at where we are ending up with unconscionability. What I wanted you to see, though, is how 99 point, add as many nines as you want, % of contracts are the kinds of uncontracts we have just finished describing. Almost none of them are the black letter law contracts. Even our two big types, companies negotiating carefully with other companies, or companies doing these long-term supply contracts under the Uniform Commercial Code. That is just not how most contracts are working, and fewer every day fall in that old category. For example, when you sign an employment agreement when you become attorneys, go look for the arbitration clause. It'll be in there. Right? That stuff started online, but now it's being pushed back into real space. All right. Any questions on where we are and what we're doing? Let's use this as an opportunity to wrap up defenses and anything else that you've got in the class, and then we will move into remedies, which is our final section of the course. Yeah, Valerian.
Can you explain the difference between old unconscionability and new unconscionability?
You bet. Especially since courts routinely still use old unconscionability language for new unconscionability questions. The one easy place to see the difference is in old unconscionability's shock the conscience test, which still gets trotted out in new unconscionability cases. But I just want to remind everyone, is anyone here shocked to find an arbitration clause in a contract? No, right? There's no sense that this is an unusual transaction in two bad ways. That is how we would do old unconscionability. The transaction is unusual, it stands out, it falls outside of the norm in two bad ways. It's got a bad way of being negotiated, that's procedural unconscionability, subcategories oppression and surprise. And it's got a bad result, which is a bad price, but usually a bad price plus something that makes it look awful, right? Like, for example, a bad price on a solar water heater, but the real kicker was that the woman lost her house because that was taken as collateral for a water heater that, oh, by the way, I didn't add this fact. The water heater actually never even worked. Like it never, like, they tried to get it working, like it wasn't even a thing. You can see those facts really matter for substantive unconscionability. All right, that's old unconscionability. As we begin to transition to new unconscionability, first of all, these are entirely my internal framework. I've been teaching this stuff for 20 years. This is my sense of the evolution of the law, but I think it really works. New unconscionability is focused around this problem of arbitration, of forced arbitration, mandatory arbitration, and the way in which that's been used to deprive humans of their ability to go to court. And in that sense, therefore, we're going to change our intuitions. It doesn't shock the conscience that there is an arbitration clause in the agreement. The only thing that would shock it is if there wasn't. It's much more the problem is the dispute resolution process itself and its distinct features. And this really works out in some wild ways. For example, oppression and surprise oppression becomes less about, as Chris was pointing out, a salesperson pressing into the house and not leaving. That's textbook oppression under old unconscionability. Textbook oppression under new unconscionability is there is no market option. Where are you going to go to find that equivalent of literally when you get employed? Where will you go to find an employer who does not put one of these damn clauses in your employment contract? Good luck finding one these days, right? That becomes new unconscionability oppression, that there's no place to escape it not because these practices are so unusual, but there's no escape because these practices are so usual. That's a hell of a flip, right? And then surprise becomes something different. Surprise in the traditional context might be a person who doesn't have equal bargaining authority, doesn't understand the language of the contract, or is being channeled and directed in certain ways in order to keep their eyes off the contract. Whereas surprise in the new unconscionability framework is a rough one. Sometimes it just gets equated to conspicuousness. Remember when we said like certain things need to be conspicuous? And so it has to do with like the location of it within an electronic contract, which you're just gonna see and hit I accept. And it's really hard to say that once you saw it and had an opportunity to pull it down to the bottom, you can accept. By the way, practice tip, your standard attorney best practices for one of these new contracts to avoid that kind of surprise allegation is a mandatory, non-leaky, pull-down, click-through agreement. Mandatory means once you fire the device up or you go on the site, boom, there it is. That's the contract, and they have got to go through it. It is mandatory. There's no clicking around, closing it and getting in anyway. It is mandatory. Non-leaky, there's not going to be a way to get through it or around it. Pull down, you're going to make them go to the bottom of the document all the way down to at least give the court the sense that, okay, all the words did pass under their eyes. Never mind this thing was 75 pages long, right? But all the words did like pass under their eyes, and then click through, make them do something to accept it. Mandatory, non-leaky, pull down, click through agreements are the gold standard for sort of shoring up these quite obvious otherwise arguments that like it's on page 74 of a 75-page document. And everyone knows that no one has the time or sanity to read these things. And so surprise becomes about the design of online contracting under new unconscionability. Similarly, under substantive unconscionability, there's a difference. Remember that in our solar water heater case, under substantive unconscionability, we basically had not only a bad price, but bad practices around it, right? So a bad price secured by her home, and it didn't work. That's a perfect, clean example of substantive unconscionability. Bad bargaining process, that's kicking in the door, not leaving her house, yielding a bad result. She got sold a product that she couldn't pay for, that never worked, and then she lost her house because she couldn't pay for it, which everybody apparently knew about. Different kind of substantive unconscionability in the new unconscionability cases. Their substantive unconscionability is very focused around a concept called mutuality, which is still mutating. Mutuality, because this whole area is undergoing very, very rapid mutation because it's under such intense selective pressure, right? Unless you evolve the law here, you're not even in court. This is literally the only law that can evolve, right? Because everything else gets knocked out and gets killed off and gets sent to arbitration. So this area is, of course, mutating wildly because it's under such intense adverse selection. Mutuality started as this idea that you can't put one category of cases that the drafter cares about in court and another category of cases that the other party cares about, that all has to go to arbitration. Courts began to object because that was going to create a one-sided development of the law. And you can really see this. The key place that this always happened, a friend of mine was looking at he was going to Airbnb or some equivalent property manage his home. He's got a home on the West Coast, moving back to Virginia for a minute. And so he wanted to put his house under property management. And you look at the property management contract, and they did this. They're like, look, any fights about trade secrets, intellectual property, use of our logos, all that stuff, that is going to go into court. We need to be able to develop precedent around it. But any fight you have with us about the quality of the services that we provide to you, if we burn your house down or whatever, that all has to go into arbitration. And I told him, like, one, don't sign it, and two, you might want to just tell them that they need to talk to a lawyer because that's a wildly unconscious, like, it's just an obvious. What that is on the bar exam is a freebie. What that is on my exam is like just somebody handing it to you. Be like, yeah, that's unconscionable, like easy. That is obvious new unconscionability. The mutuality doctrine, though, then began to get more teeth. And just like we watched that, remember when we watched equitable estoppel kind of turn into promissory estoppel? And we said, we can watch it mutate, but they're not the same thing, right? It's not the same thing to say, I said one thing to a court at time one, therefore I can't say something different to that court at time two. That's equitable estoppel, right? Promissory estoppel is, I told the other party something at time 1 and then I took it back at time 2, we're not bound, we weren't before those cases, we weren't bound by principles of candor to the court, tribunal, officer. We weren't bound to say correct things to the court when we're talking to opposing counsel, especially before litigation, right? So where did that come from? That kind of mutation is what's happening in mutuality. Mutuality used to be about this sort of bending the arc of case law in one direction and then stifling it in another direction. But it rapidly became when one party either actually or functionally has a power during the dispute resolution process that the other party doesn't have. And there's 2 categories of that. If they actually have a power during the dispute resolution process, be worried about it. And by the way, I'll give you an example. I'm fairly hard on arbitration clauses. I think they're an awful development, et cetera. But I'll give you an example where it's like, even I begin to crack here, right? There was a case I was involved with where essentially it was a video game company, and they sold plots of virtual land. And what happened was one of their users found out that those plots went up for sale for auction, that they actually had the links live before they were posted. And so he was just predicting what lots were going to come up next, creating a URL, just like seeing if it was there, getting through to the link, and then winning the auctions for tiny amounts of money because no one else, because the link wasn't live yet, it hadn't been put up for auction yet, and so he's just winning all the auctions. Whatever you think about the way that case worked out, which is 1, they banned him for doing that, which fine. 2, the reason I got involved as a digital property attorney is because they also took away all of the things that he legitimately purchased, which is not how that works at all. But at the time, then there was this mutuality discussion. And the mutuality discussion was around the fact that the video game company had the ability to ban him from their service, and he didn't have the ability to ban them from anything. Well, look, if somebody's suing you, you don't actually have to keep doing business with them. This is starting to get a little bit crazy here, but it was a legit, go look it up, it's Linden Labs. It was a strange case because the court was like, yeah, one party has this ability to stop doing business with the other party, whereas that other party doesn't have the ability to stop doing business with them. Seems iffy. The reason I'm giving you the Linden Labs case, though, is because I want you to see how far this idea of mutuality can sort of mutate and twist when we're beginning to try to put pressure on these arbitration agreements. All right. So that's another key difference. The difference in procedural unconscionability has to do with the bargaining process offline versus the bargaining process such as it is online, and that's where we're going to capture differences in oppression and surprise. The differences for substantive unconscionability go to price and terms offline. Online, they go to whether one party has a power, either actually or functionally, in the dispute resolution process that the other party doesn't. The functional part, remember from AT&T Mobility and from Ferguson, frankly, the functional part is something that looks equal might actually not be equal. And we saw that with the deposition limits, saying, Countrywide just needs to depose the plaintiff, right? And the plaintiff needs to depose the entire HR department. And so it looked equal, but it functionally wasn't equal. And that's what mutuality is going to be. Mutuality is going to be the sort of big heavy hitter in our new substantive unconscionability analysis. Great question. Chris?
So arbitration is just like nuking contract case law.
Yep. It really is. Aiden?
Could you tell us a little bit about the scales of substantive unconscionability and the effect that taking the weight off of the class action waivers had?
Wonderful. Well, so hang on, the scales bit. Maybe I'll need a follow-up because I'm not quite sure I understood the last 4 words there, but the scales bit's important. Most jurisdictions require you to have both procedural unconscionability and substantive unconscionability. You can see why, right? To say, oh, I got a bad price through the fairest possible process of negotiation. okay, you suck. Right? That's not going to be unconscionable. Let's try it again. Let's say, oh yeah, worst possible bargaining environment ever, totally take it or leave it, totally, right? But I got a great deal. Who cares, right? You need both. The one thing, though, that's important is many jurisdictions, probably a majority of jurisdictions, have a sliding scale. This is what Aidan was raising. They have a sliding scale. The more unfairness you have in your bargaining process, the less unfairness you need in your result. Or the more unfairness you get in your result, the less unfairness you need in your bargaining process. And there's one further thing to say about that, which is in most jurisdictions, you are almost always kind of there on procedural unconscionability, and that's because these contracts are all take it or leave it transactions in which there is no real bargaining power. And so you're all, right, you always got a little light unconscionability going on. You always have a little light unconscionability in your bargaining process. And so if you can just show that the arbitration agreement is terrible, you're usually already there. So there's this sliding scale. The more you get of one, the less you need of another. And note, you're already kind of halfway there out of the blocks. You're halfway there in many jurisdictions purely because of the take it or leave it transaction. Now that's the sliding scale stuff. What I need you to know is in almost every jurisdiction, you do need both. Sometimes cases get confused, but that's not even really a jurisdictional rule. Like they just kind of get a little bit messed up. I'm comfortable saying pretty much all jurisdictions need both. Some of them do a sliding scale, and you want to be aware if your jurisdiction is one that does a sliding scale, because that can let you really load up on the place where you're going to win, and that way you can have a lighter touch on the place where you've got the harder argument. All right, now is there a follow-up to that? Because I feel like I answered about half your question.
Yeah. Could you go into the interplay between the scales and the what you call the Cadillac arbitration agreements?
Yeah, absolutely. Right. So the Cadillac arbitration, such a great question. The Cadillac arbitration agreements, the trick there was they don't want it to be substantively unconscionable, right? They want it to look as good as possible. Why? Because courts continue to have legitimate concerns about the utter freaking lack of bargaining involved in modern mass market contracting. This is the law of bargain for exchange, and you've just told the court there was no bargaining here. There was no other way to do it, right? Because if there was, we wouldn't have gotten there, right? If there was another option, if you could have just gone to a competitor and gotten the same deal elsewhere, probably even California would be like, well, that's not unconscionable. So you're already well down that path, and because of that environment, because you're already sort of this is not technically true, it's just kind of a feeling, it's a vibe. You're halfway to unconscionable on procedurally, sort of just from the jump. You really want that Cadillac plan so that you can say, oh, well, maybe there are concerns that one side is bearing a cost. And let's write these down, right? Because these are ones that are being signaled in new unconscionability. If one side bears a cost that they would not bear in court, then that tends to be a finding of automatic unconscionability. And so what do? They Cadillac it. We'll pay all the costs, which they did in that particular case. They said, or you might say, well, there are limitations on, there's a venue where you can go. Don't worry about that. We'll make it super easy for you to do remotely. You can drive down to Roanoke. This is true. You can drive down to Roanoke, and they've got these little booths that you can go into and have your rights taken away, in the full comfort. So it's very comfortable to lose these cases. That they're very into that, and so on and so forth. The Cadillac features are meant to alleviate and avoid these obvious pitfalls. Do not do, and I mentioned these previously in class. Do not do, as I have seen, the deal where you're requiring somebody to litigate, to arbitrate under the rules of the International Commercial Court in Marseille in France. Right? Don't send them to Cairo. I saw that one in a case. Don't make them pay for things that they wouldn't have to pay for in court. Don't set up deposition frameworks that are going to be unfair. The point is, with each of those, you can address the concerns by Cadillacing it. But the problem is that that's not reflected in the law of the Federal Arbitration Act, which means you're not going to find these Cadillac plans now, right? They have been profoundly, using Cory Doctorow's wonderful term, they have been enshittified. And they've gotten worse and worse as the law enforcing them has gotten settled in. But that's how it interacts with that. All right, Nate, you had your hand up.
I had a question about modern new unconscionability oppression.
Yep.
You said that when there's no other market option, but is that correct? Because I know if you're employed, like if you're trying to get a job, you're not going to have a better market option than to take an arbitration clause.
Yeah, well, that's the point about oppression overall. Even California law used to say, when this fight was really warming up, they used to say, look, if you could go get the same deal elsewhere and avoid the arbitration provision because they didn't have it, or you could buy it somewhere else, that's okay, like that's fine. We're not here to protect you from making bad deals. We're gonna deem it oppressive if we can demonstrate that there's no other place, that there's nowhere else to go. It was a series of cases. Does that make sense?
Yeah. And so now.
Yeah. Like, I mean, 10 years ago, I think you might have been able to get a law firm job that didn't have an arbitration clause. Bet you can't now.
But we wouldn't really have a good oppression argument.
Oh, you'd very much have a good oppression argument.
If the deal is fair, then it's harder to make.
You got it. If the deal is fair, then it's harder to make the overall deal. All right. More. Scott.
Sorry, just going back to the last point about why we moved away from the Cadillac arbitration clauses, is that essentially because the FAA has just been shown to be such a supporter of arbitration, and after like
Right.
AT&T, nobody wants to call an arbitration clause unconscionable?
And also, well, and not only that, but it's also just costly. Like the Cadillac terms were really encouraging parties to go to arbitration. They were trying to make it look to Justice Scalia like this was a market competitive alternative, that it was a good idea to save the costs of litigation by having the parties engage in private dispute resolution. Like, I hope the best for you in your relationships throughout your life, but should you decide to divorce, mediation is not a terrible idea. Right? You can really save costs that way. But the trick was they forgot to say, yeah, that can be subject to market forces. A lot of free market people who are like not into free markets around here, right? Like, if it's actually going to be better in the market, why don't you let people make that decision? And that's the forced part of the arbitration. That's what they really forgot. Okay. Any other questions before we switch tactics? Okay, cool. So turning to our last big category of the class, we'll do this and we'll do some cleanup and then we'll do exam review and that's it. We have done contract formation. We have done contract formalization. We have interpreted the written terms of the contract. We have inserted the implied terms of the contract, which are not written but are still part of the contract. We have then said what happens if we have all of those things and we still decide not to do it. Those are our defenses. We have illegality, public policy, restraint of trade, unilateral mistake, bilateral mistake, and unconscionability. Those are our defenses that we looked at. And now we're going to move into, really, for those of you who saw the paper chase, although fewer and fewer people do every year, we're moving into where many contracts courses used to start about 50 years ago, which is at the end, and that's why we don't do that anymore. We should start with contract formation. That makes a lot more sense. But they would start at the end and say, what are the remedies for breach of contract? And I'm going to give you an opening set of ideas around remedies, and then we're going to really bear down on them. We don't have a lot of active cases today, so some people who've been put on deck randomly may not get called on today, and that's fine. We'll have more cases next time. But I do want to give you a basic sense of what's going on with a remedy. If you remember the difference between detrimental reliance, promissory estoppel, Section 90, and a breach of contract claim, it's this, that the Section 90 promissory estoppel is essentially trying to put the injured party in the position they would have been had the promise never been made. Never been made. They're not trying to get you to enforce the promise. They're just saying, fine, let's put you in the same position you would have been had that promise not been made and had you not relied on it. Whereas a breach of contract action is going to try to put you in the position that you would have been in had the contract been kept. That is the fundamental statement of remedies under contract law. That the injured party should be put in the position that she would have been in had the contract not been breached. So why then that sounds like a perfectly straightforward remedy, but why then are we sort of left looking at all three different kinds of remedies that we've got, and we're looking also at a couple of different kinds of remedies even for expectation? And the answer is because all the king's horses and all the king's men couldn't put Humpty together again. That universe in which the promise had been kept doesn't exist. They didn't keep the promise. And it's really hard to prove facts and features about a world that doesn't exist. Already, we forked the timeline. Already we're gone down that other path and other things are happening. And that makes the process of sort of fixing this really, really problematic. Because you're trying to create a world that doesn't exist. And courts don't have the resources to create that world even if they could do it. And so the problem is that we've got a standard that's very clear, but it's impossible to meet. And that'll give us our first intuition. When we're talking about, and this is what I am talking about, the expectation measure of damages, which is our gold standard for a breach of contract action. The expectation measure of damages is what we've just described, and yet we see an immediate workaround. And that immediate workaround, and you should look for it every time, the immediate workaround is alternative performance. They will just simply ask, hey, what's it gonna take to get somebody else to perform the contract in the way that was promised to the injured party? That's all they've got. Because you can imagine all kinds of objective and subjective problems here, right? What was the value of the performance to the person to the recipient of the breach of contract? We can't tell what the value is. All we can tell is what they offered in the contract. That's their revealed preference to pay. Everything else is their own hidden preferences. And of course, as we discussed earlier, we will never force them to reveal how much they would have paid, right? So we're kind of stuck. Now, after the fact, they're coming up and saying, this was worth $1 billion. And you're like, was it really? Why don't we just pay somebody else to perform, take that bill, subtract the contract price, and say the degree to which you had to pay more to get this performance than you would have had to pay under the contract price, that is going to be your measure of damages. So that is our very favorite way of uncracking that egg. And those are called, in the UCC, those are called cover transactions, and we will look at them. Under the common law, they're called alternative performance, the cost of alternative performance. And it is an absolute gold standard for solving this problem of interpersonal comparison of utility, if I can use our economic speak for a minute. The idea that we have no idea, not only can we not uncrack the egg because the parties didn't perform, and so we've already gone down a different path, we can't uncrack the egg because we can't even figure out what the value of performance was to anybody. We just know the minimum it was worth. We don't know what it was actually worth. We have no way of doing that, right? So we go with alternative performance as a way of just kind of trying to clear cut those problems. If we can't get alternative performance, and this signals a major change in our thinking, if we can't get alternative performance and we can't get good language about alternative performance, there's a couple of reasons why that might be true. First, we can't get alternative performance because if I am offering to sell you the French crown jewels, which strangely enough I just came into possession of. It's really strange. I don't know how that happened. But you can imagine that if I were just going to sell you the crown jewels of France, and then I breach, what kind of alternative performance are you going to get out there? So, what do we start doing?
I would think that you immediately have to go to I'm
Specific performance. This becomes our circumstance in which the world is so unresolved, like we can't replicate that world because it's a unique transaction. There is no alternative performance. There's no way of valuing it differently. So what do? We get a court order to convey the French crown jewels to you. That's a straight up court order to do the contract. That's a kind of alternative performance. It's saying you breached the contract? Cool. Yeah, don't. But there are real reasons why that turns out to be a disaster. And then as with almost every lawsuit, it's not as cool as you might originally think to get specific performance. But that's one way we cover for one set of loopholes around this. But the other set of loopholes that we start taking a look at, and a reminder, by the way, that specific performance is actually the default remedy internationally under the CISG. You may have forgotten, I'm now reminding you. That is one of two things that you need to know about the CISG. The one thing you need to know about the CISG is there's no parole evidence rule. And so people can just put people on the stand to say whatever the hell they want. But the other thing you really need to know about the CISG is that specific performance is the default remedy. And so that can really catch American companies by surprise. All right. The second way, though, that we begin to deal with this, like what's the circumstance in which the parties had a deal, one party breached, and we don't have a good alternative transaction. And that follows this scenario. And it both is a rule of setting up this whole framework. What I'm doing is I'm giving you a framework for expectation measure of damages. And then I'm also setting up a big problem, and it's a big shift from the first part of the course to this part of the course. This part of the course has got a different villain than the first part of the course. Remember all this time we spent getting the court mad at people? We're now about to shift who we're mad at. We're about to be mad at the person who suffered the breach of contract. And here's why. In the remedy phase. And here's why. Let's say that you and I have an agreement. So I agree to sell you a specific Ford F-150 that does not move up on my property. We'll call it the paperweight. And you agree to buy it, right? And then for whatever reason, I breach. Maybe the attachment, right? My third daughter named that truck Rosie. We have a little, it's Rosie truck. We have a little Lego red truck that she and I built together about it. Like maybe I just am overcome with sentimentality at the last minute and won't sell the truck. Let's say then that you go out and buy one of those half tank, half monstrosities that passes for an F-150 right now. That is a brand new one. And you get you get it gold plated and you get all the runners and you get it detailed with like Pokemon on the side. And then you take that bill, that cost, and you bring it to me and you're like, look, that was an alternative substitute transaction. I think everybody can see that is not an alternative substitute transaction. That is opportunistic behavior. Can you see how one party's breach of contract creates, if a court doesn't watch it, a free option for the other party, right? And so we're now going to start fly-specking their behavior in securing alternative performance. Here's what I want you to know. Expectation measure of damages, impossible to uncrack that egg. What do we do about it? We usually look for alternative performance first, but if the non-breaching party engages in an unreasonable alternative transaction, we say no. And this is elegant, but it's worth seeing at the beginning. What do we do then? What would you do in that scenario? If I had offered to sell you the F-150, you had accepted to sell the F-150, we'd agreed on that, I breach, and you go buy a brand new F-150, which costs, those got to be above $60,000 these days, right? At minimum. My truck would not be that price. Just saying, if anybody's interested. Those, right? What would you do as the judge? Like, we know what you're going to do as a judge. We're just going to have to give words to it. Chris, what are you going to do?
I need you to prove to me that those values were parallel and that both sides understood as parallel, or I'll just give you 6 cents.
Yeah, or I'll give you 6 cents?
Yeah.
Okay, and how are we going to calculate 6 cents?
I don't really know how they calculated it. It's like a middle finger, honestly.
Yeah, no, it really is. You talk about Freund here, like the court's like, just no. right? Yeah, there's a. I think you'll see it when we get to it later on. Here's what they do. They say, wait a minute. Let's look at what would have been a reasonable purchase. You didn't engage in a reasonable purchase. What you did was you tried to exercise a free option at the expense of the breaching party. You said, oh, cool, you breached a contract? Fine, great. Now I'm going to use that as an opportunity to go buy with your money, to go buy with your time, to get whatever I want. What courts are going to say is, no, look, if you arrange for a reasonable, fairly close, but a reasonable substitute transaction, we're not even going to look at this. Great, those are your damages. Give me the receipts, we're done here, we go home, right? But if you engage in an unreasonable transaction, what they'll do is they'll reduce your damages to the amount that you would have gotten if you'd engaged in a reasonable alternative transaction. They just use the subjunctive mood with their verbs. What would you have gotten if you had, right? Would, had, these are subjunctive. They imply lack of reality. They're describing what didn't happen, but what would have happened. And so they'll reduce your damages to a hypothetical replacement transaction that was reasonable. What I want you to see is that is the first two places a court's mind's going to go with the expectation measure of damages. We're trying to create a world that can't exist. You can't uncrack that egg. Fine, let's get an alternative performance. Crap, the party involved didn't get an alternative performance. They went and got a Pokemon labeled F-150. Okay, we'll just recreate the world in which they did act reasonably, in which they did get a reasonable substitute transaction. And then if it turns out that I offered you this F-150 for $500, and I think this is actually true, like the Blue Book value, even with a V8 engine that doesn't work, like the Blue Book value of the truck is somewhere north of $1,000 right now. And so that's your reasonable alternative transaction. Well, then that's your measure of damages, right? Your measure of damages is $500 because that's the amount by which your replacement transaction was more than your original transaction. All right. What I want you to take out of this is the following. I want you to take out of this an understanding of the expectation measure of damages. I want you to take, and the idea that it's trying to create a world in which the parties had kept their promises, why that's impossible to do, and then what courts do about it in terms of favoring alternative transactions. And if they can't favor an alternative transaction, they will create a hypothetical alternative transaction and roll with it. Now, that's not what they do in all cases. We saw in the French Crown Jewels situation, they solved this problem by just issuing a court order saying, thou shalt perform the contract. But broadly speaking, that's what we're looking at for expectation. Do you guys have any questions on expectation, on why it's so damn hard to calculate? You should really feel that in your bones. And then why courts anchor so hard to these alternative performance metrics.
If you get a cheaper alternative performance, can you still get damages for the time delayed with the contract date, or do you just get 6 cents?
Oh, wow, that is such a fantastic question. Okay, cool, here we go. You cannot get direct damages because you haven't suffered any. The replacement transaction was less expensive. Sometimes you can get what are called incidental damages. Incidental damages is one of my favorite because it's in my upper level sales course, it becomes just wildly testable or not testable. Incidental damages is one of these categories that just gets moved all over the place because it's badly drafted in the code. What incidental damages are supposed to mean is incidental damages are the damages that are incidental to arranging the alternative transaction. So if you have costs in arranging the alternative transaction, whether or not it's a good deal or a bad deal, you get those incidental damages. And if most courts have gotten the meme, and most courts will say, yeah, you can recover incidental damages, even if there's no underlying damages in the contract because the replacement transaction turned out to be cheaper. Like, you're happy, you got out of a bad deal, right? You had a bad deal, the other party breached, you're really pleased about that, you go get a better deal, but it costs you money to arrange that. Maybe you can have incidental damages. Great question. Yeah, Graham.
Or is incidental damages the same as what the textbook refers to as consequential?
They are not, and boy, am I going to talk to you about consequential damages here in a minute. They are, in fact, expressly distinguished from consequential damages, and consequential damages are not your direct damages either. So we are going to have a conversation about consequential damages here in a minute in terms of what that means. That is a harder one to hoe. That said, incidental damages are not under the code consequential damages, largely because some of the statutes say you get incidental and consequential damages. So if they're using both words, they must mean different things. But due to a drafting error in one part of the code, sometimes incidental damages get brought into the broader meaning of consequential damages to see if maybe they could be recoverable. That's something that we'll focus on, what consequential damages are. All right. Anything further before we begin to talk about the difference between direct damages and consequential damages? Cool. As you saw in your agenda, we are looking at some UCC provisions and some restatement provisions. For our expectation measure of damages, we are looking first at 2708, 2712, which is our cover remedy. Cover is our alternative performance in our framework. And 2713, which is our hypothetical alternative remedy. If you had the opportunity to cover, but you didn't, or if you had the opportunity to cover and arrange that cover transaction, but you instead bought something gold-plated. In both of those circumstances, the court's going to say, nah, we're going to kick you to a hypothetical market transaction, what you would have gotten if you had acted reasonably. That's the statutory component here. 1305 sets out our general egg world, which we're trying to uncrack, and then 2708 sets out the expectation measure of damages, and 2712 and 2713 set out our alternative performance, which is the preferred version. And then if you screw up or don't do alternative performance, you get your general hypothetical alternative market. So the UCC follows what I've just said, like exactly. You'll see the same contours in the common law cases, but it's sometimes useful to see the UCC first because it's just real clean. Now, in that case, just to reiterate, because now we got to go to Graham's question. To reiterate, what are your damages if I offer to sell you my truck for $500, you agree to buy it for $500, I breach, you go buy another similar truck for Kelley Blue Book, which turns out to be $1,000. What are your damages? Leland? 500. And not only that, those are your direct damages. Now that I've told you that, can anybody go, oh yeah, I can totally explain to you why we're going to call those direct damages. Why are we going to call those direct damages? Because we got some other categories. David? Because it's the direct cost, right? Can you see how that would put you in the same world under 1305? We're going to call this 1305 world. It's going to put you in the same world you would have been in had the other party not breached, right? Think about it. In the world in which I never breached, right? Your bank account goes minus $500 and you get a truck. The world in which we now live, you have paid $1,000 and you have a truck. What do we do to put you back? $500 and a truck. And we've now equated the worlds. The worlds line up with each other. No. Right? Okay. But of course, then there's this alternative problem, which is what happens if it costs you money to get the truck, to arrange the alternative transaction. And that's where your incidental damages are going to take place. But there is a third kind of damages, and this is the big one. Can anybody take a crack at what consequential damages might look like in this framework? Yeah.
Hypothetically, if someone was going to use your truck to go to class,
right,
if it could make it,
right,
that's alternate universe.
That is.
And they can't get to class or can't get to work. That's a consequential.
That is a consequence of the breach. This is not the direct damages caused by the breach. This is something that follows on the breach. And I need to check something here because I want to make sure that we're not teaching this somewhere else in the class, because I'll feel like an idiot if we do. Okay, sweet. Whew. All right. Yes, we go over one of the most important cases ever. We just do it much later. Okay, so look for that. For now, I just want to flag it for you. When we're talking about damages, the expectation measure of damages involves, at least as a rough cut, undoing all three categories. Your direct damages, that's the difference between the deal you were offered and the deal you got through alternative performance, or should have gotten through alternative performance if you had acted rationally. That's one. Two, incidental damages, the costs of arranging alternative performance. And three, consequential damages, down the road impacts that hit because the person involved was not able to execute that. If you needed that truck to get to class, and I understand we're changing the hypo because now the truck works. You needed that truck to get to class, you weren't able to get to class. Under what circumstances can you begin to claim damages for that? And those are our categories of direct, incidental, consequential. You will often hear courts talk about direct and indirect damages. Sometimes they'll talk about special damages. Usually what they mean by special damages is they mean consequential damages, whereas direct damages are the immediate loss. And as you might assume, every contract ever basically tries to disclaim consequential damages and succeeds usually in doing so. This is one of the big ones you want to knock out. You want to knock out consequential damages because they can be huge, right? A little mistake can cause a company to collapse consequentially, and then you're on the hook for the whole company. Yeah, you don't want that. All right. Any questions on this basic framework before we begin to start getting into these cases? But I did want to set up what you're looking at so you have an ability. I know it's taken us a minute, but I want you to have the ability to sort of stare at this and realize what you're seeing as we move through them. Questions? Sweet. Then let's turn to Freund versus Washington Square Press. And David, if you wouldn't mind setting it up for me, please.
So Freund is an author and teacher who sued Washington Square Press for failing to publish a book and breaching the contract. The deal was that in exchange for $2,000 advance in royalties, Washington Square would sell and publish the book.
Yep.
But they backed out within this. They could back out within 60 days if the book was terrible. But the manuscript was delivered to them, and they refused to publish past those 60 days, and because they merged with another company. The trial court granted $10,000 to Freund to cover the cost of publication, but this was measured based off of how much Washington Square saved from breaching the contract. This appellate court reasons that money damages should, in theory, give the injured party the benefit of the bargain subject to the amount of damages claimed being reasonably solvent in measurement. However, it also can't give the injured party more than if the contract would have been fully performed. And this court believes that measuring damages based off of the cost of publication to Washington Square would do that. They state that the trial court mistakenly based damages on how much Washington Square saved through breach rather than by the consequences of the failure to publish the form. However, these consequences of the loss of future royalties, not the amount of these consequences are the loss of future royalties, but the amount of royalties Freund would or would not have gotten was unsolvent. They weren't within the required amount of certainty that Restatement Second, Section 352 requires, and therefore only the nominal damages are recoverable, and that's why they lowered the damages from 10,000 to 6,000.
Okay, superb. And in a minute, I'm going to ask Lauren to take the other side here. But to start, which side do you want on this?
I'll side with Washington.
Okay, so you're going to side with with the press. But it's just an interesting one because like people tend to pick the winning side, right? I mean, who won here? Technically the plaintiff, right? But I think if you were the plaintiff, you would not love this outcome. Right? This is awful, and so we need to try to figure out why they're doing that. All right, so Lauren, let's turn to you then, since you're going to be running on behalf of the plaintiff. What is your client actually pissed about? Right? Because we're in a lawsuit, and you do not come cheap. You're a high-powered attorney. So, like, this professor, and we're not like wildly well paid for our time. So this person's like come up with a lot of their personal capital to pay you to bring a lawsuit that's moving past the, like, not only the district court level, but then appeals. Like, this is a minute. Why?
Well, them not publishing delayed their academic promotion, and then they went ahead and didn't terminate the agreement within 60 days, so they're violating that contract, that agreement that they had previously. And then they're refusing to pay for the cost of publication, had the arrangement to publish it completed.
Ooh. Nice. I like that second bit. I like how you reframed it because there's and I want to sort of tease out the difference between what David said and what Lauren said. So, David, how did you characterize the $10,000?
It was based off of how much Washington saved.
Washington saved. And Lauren's already knocked a home run out of the park here, but we need to see exactly what's going on with that set of arguments. Why are we not going to do that? David? Why is it that it is entirely correct to say, when I breach a contract, the measure of damages that you get is how much I save from breaching the contract? What is really, really wrong with that picture? And this is something that in our remedies, we're going to get to again and again and again.
Because the point of a contract is, the point of remedies is to get them in the same position that they would have been.
Yeah, tell me what the difference then. So you're not, and this is exactly the difference, by the way, between the two standards, right? You're listening to this, right? Because you framed it differently, and that's going to be awesome. But the idea is to put somebody back in the position they would have been in had the other party performed. And if I save $100,000, and I don't know, I can't figure out why I would save $100,000 by refusing to sell you my truck. But let's say I do save that amount of money. Like, that has nothing to do with a world in which you are down $500 and you have a truck, right? That's your 1305 world. The fact that saves me a world of hurt. Maybe, I got it, maybe my third child will convince my wife to divorce me, right? And so that will, like, by selling the truck, I have put myself in a world of hurt. This still could happen. I'm going to put myself in a world of hurt, right? But that's not 1305 world. That's not our, under the common law, that's not our alternative world, the world in which the contract had been performed, right? Okay. Which makes the strength of your framing really come through, because you didn't say the 10,000 was the amount that they saved. You said it was...
It's the cost of publication, so the royalties that I would have gone to.
We'll get to royalties here in a minute. So you're casting that $10,000 as the cost of getting it published. How is that different, Lucas?
That's your alternative performance.
That's the alternative performance right there. And the whole mystery of this case is, why doesn't the court go for it? But that is absolutely your alternative performance. Go ahead.
I'm just gonna guess why.
Go for it. Yeah, why?
I assume they can't get alternative performance.
So one, they can't. This is a subject very near and dear to my own heart. Like, I've been promoted to the top of my profession. You know, I'm a chaired professor of law. This does not have the same impulse. Let me tell you, when I was up for full professor and my book contracts were coming out, I was not as lackadaisical about getting the manuscript in as I am right now. My book for Oxford is now like 2 years overdue. They may just like kick me out. That's fine. But like at that time, it really had a lot of oomph. Yeah, Lucas.
They're not going to give him the 10,000 because he didn't actually pursue that alternate performance. And if they just gave him the 10,000, he could just keep it, and that would be 10,000 profit. He wouldn't even have to ever get the alternate.
that is you begin to worry, right? You begin to worry. Remember this shift I was warning you about? We stop looking for opportunistic behavior on behalf of the breaching party, and we start looking for opportunistic behavior on behalf of the other. What are some facts here that might make you, if you saw those facts, you're like, yeah, I don't think you're going to use that $10,000 to publish a book. He'd been promoted anyway by that point, like the lawsuit had gone through. He was able to parlay this into enough points. Yeah, go ahead, Nate.
Someone else published a book that won a Pulitzer Prize on the same exact topic.
So somebody else has already published, and so now it's looking much less likely that he would try to occupy that same academic real estate. There's a bunch of reasons where we're just thinking, we don't believe you, man. We think this is going to be. Lucas, you want to take a guess at how judges describe this problem of like you just get $10,000 and you're like, oh, hey, free money. Take the money and run. We call it, if you're going to argue this in your facts section, we usually call this a windfall. So when you say, look, the defendant's proposed remedy in this case, plaintiff's proposed remedy in this case would constitute a pure windfall. And in a way that explains most of the case, right? Most of the case is settled out by this difference because we're really saying what's the closest we're going to get to the world in which the contract was performed, and there's this alternative performance standard kind of glowing out there and blinking at you out there, and the real question is, why does the court not go for it? And the answer is, well, because it's a windfall. Like, we don't think you're going to do it. We think this is just going to be overcompensating you. So far, what's happened here is, sort of David's raised a defense, right? Lauren's kind of gone. David, I do want to come back a second. Why don't we take the benefit you receive from breaching the contract and turn that into the damages?
Because that's not what the goal of remedies is. The goal of remedies is just to help the injured party recover, not anything more.
Right. That is to recover anything more. My question, though, is why? Why do we set it up that way?
Because it's not Pareto efficient.
Because it's not. All right, now we're talking. Because it's not efficient. And we're talking about a very specific kind of efficiency here. What kind of efficiency are we talking about? What efficiency are we protecting?
Pareto, right?
It is Pareto efficiency.
Efficiency of breach?
Yeah. We're now not protecting the efficiency of the contract. It is a Pareto efficiency claim, right? You're absolutely right. It is. But we're looking at efficiency of breach. Megan, what would efficient breach look like if there were such a thing? And where have we seen efficient breach before? Okay. Go ahead. Yeah, right? Did we want that contract to be performed? No. The world was better off if it wasn't performed, which is, I'm just being pedantic as fuck. What?
I mean, the goal was worth much less money.
Much less money than the effort to get it out there, which means we do not want you to perform this contract. We want you, as a society, we want you to breach the contract. Now, we got to get back to your point on this, right? How in the hell can we make breach of contract, the defining characteristic of which was that, remember Pareto efficiency, right? We said this is Pareto superior. Yeah, we got to stick to that. The whole definition of the contract was that it was Pareto efficient, meaning at least one person was better off and no one was worse off. That's our Pareto efficient. How the hell do we recreate Pareto efficiency, Pareto superiority in a breach? How do we say the breach is making at least one person better off and other people no worse off than they would have been before? How do we do that, Nate?
We restore the injured parties differential, and we allow the breacher to keep the profit. as long as they cover the, like, future, benefit to the injured party.
John, you gonna say?
That's more or less what I was getting. I mean, the kind of the cost of the breach will, or the profit from the breach will cover the other party's cost for enduring it.
You got it. Perfect. That's the answer. The breacher is better off. By the way, how do we know they're better off? Because they breached, right? Like, I mean, this is Oliver Wendell Holmes saying in the common law tradition, a contract is a promise to perform or pay. It is not a promise to perform. It is a promise to perform or make the other party whole. And so you're just saying, I'm electing. Yeah, okay, cool. I will make you whole. Breaching a contract, if it were done by decent humans, it's not. But if it were done by decent humans and you breached a contract, the idea would be like, I will make you whole. And to be clear, this does make me better off because my damages as the breacher, if I went through on this contract, are because of unexpected stuff that caused me to breach. Like, I get it, I did breach and I need to make the other party whole, cool. But my damages were gonna be like colossal, and so I get out of that and we're all great, and I get that paycheck, and then the other side gets paid off to be at least indifferent as to these outcomes. That's the theory of efficient breach. That's what we've just been talking about here, is efficient breach. And the answer to the question that I said to David, and David gave me 1305 as a response, which is a great response. We do need to go one level deeper to the theory, is to say, the reason we don't require parties to go through with their contracts, see NIPSCO, is because sometimes the contract is inefficient. Sometimes the contract shouldn't be kept. Sometimes we can keep everybody made whole and at least one of the parties is way better off. Why would we not do that? Okay. Can anybody begin to detect a problem with this picture? Like, I've given you economics, and as usual, economists are just superb at positing worlds that don't exist. Like, you know how they start with like, assume there are no transaction costs. And you look around, you're like, there is nothing but like the air is friction on my skin. Like, there is nothing, we live in a world that is nothing but transaction costs. What are you smoking? And, right, and so that, like, they're really great at these, you know, say, humans will agree to be treated badly. It's like, what humans are you talking to? Oh, only econ majors. I get it. Like that entire framework just doesn't work at all. What are they forgetting here that is sort of really part of the pushback, Justin?
I think it kind of encourages bad behavior.
Oh, it really does. Why?
Let's say, for example, I agree to use something your property to be stored after use, and then don't go through with that, doing the calculation beforehand, that breach of efficiency would probably be better off online if I just didn't carry it out.
Yeah, if I just didn't do it. Right, why not do that? By the way, what major theme of the course is it? What two major themes of the course, what two silos are in freaking conflict right here? Oh, yeah, crazy.
Bargain theory and promise keeping.
Bargain theory and promise keeping. You see it? Like, it couldn't possibly be starker. Right? Promise keeping, anybody want to give me a remedy, since we're in remedies, that is sort of the gold standard of promise keeping? Specific performance. Keep your damn promise. Right? And this perform or pay business, this efficient breach business, is clearly our bargain theory, is clearly our welfare economics theory. All right? Cool. Yeah, so the reason that we're not charging, essentially the reason we're not making the breaching party cough up all of the benefits of the breach is because if they did, they wouldn't breach. And we generally avoid rules that force people not to breach. You'll see it a couple of different places. You'll see it, one, in the very, very, very rarity of specific performance. You almost never get it. So that we're protecting efficient breach by doing that. Two, you see it here in court's selection of expectation remedies. Three, you're gonna see it in a couple of weeks when we start, there's a doctrine called the doctrine of penalties, right? Let's say if we said, we will agree on damages. We will cut the last bit of the course out. We will agree in our contract on damages. And here's the answer. If you breach this contract to sell me the truck, you have to pay $1 trillion. Can you see now why courts are just going to be like, no, that is void as a penalty? Why? Why will they say that is void as a penalty? We will not make you pay $1 trillion. if you breach a contract for a $500 truck.
Is it just because there are no punitive damages in contract law?
Well, there are no punitive damages in contract law, but that's not why this one. Why is this one? We're not going to let you put just a colossal penalty for breach of contract. Gene?
It's grossly inefficient.
Because it's grossly inefficient, because people will perform inefficient contracts, and we want to preserve their ability to efficiently breach. You're going to see this all over the law here, and we're going to come back to this theme. Gracie's point about promise theory versus welfare economics really coming to loggerheads over the economic theory of efficient breach, which we are seeing here for the first time. Okay, cool. I think that's about our discussion of Freund. I think we've sort of done good back and forth here. The court's description of remedies also lays bare one practical practice tip, which is you can win a case and lose it. Winning at the remedies phase is more important than winning the case. If you can bait the other side into a winning legal theory for which they have no remedy, go for it, right? There's winning and then there's winning, and this is the real winning. That's one final thing. Any other questions about Freund, what's going on in the case? Why? Yeah, Jake.
Also, are the injured parties ever really made whole if they still have to pay the litigation costs to go through?
Nope. That was what I was asking for earlier, right? This entire idea of efficient breach. Let's see if you can hear it, because I'm going to state the rule. A breach of contract is efficient if the party who has been injured is made whole, and the other party is at least in as good a position or a better position than if the contract would have been performed. What's the one word? I heard it. It's if, right? Because under what circumstances does one party make the other party whole?
Through litigation.
Through litigation. And y'all, if I was able to stress one thing, it is we don't come cheap. And the American rule, you guys have learned the American rule on litigation costs? Which is what? Every party pays their own costs, which means we're not even close to putting the one party in the position they would have been in had the other party not breached. Not only are we not even not close, right? But this then serves as the kind of opportunistic behavior we've been worried about the whole damn time. Because if you know that, yeah, I can breach this contract, and you know if you sue me successfully, all I have to do is pay out what I would have had to pay out under the contract. Big freaking whoop. By the way, this is the basic principle that broke our entire healthcare system. Y'all may have thought there were other issues in healthcare. There aren't. There's just one, and here it is. You want to know what the penalty is for your health insurance company if they wrongly deny your claim and you sue them and win? They have to pay. Do you see the problem? This is why, our healthcare system at the university is owned by a company that's well known to use an artificial intelligence with a well over 90% error rate to just deny all the claims, right? Because they're like, well, what happens if we lose? We just have to pay it. Big freaking whoop. Why not deny everything up front and then pay the ones that we lose? There's a huge incentive problem here if you don't pay attention to it. Economic theory, as usual, and there are other places with supply chains where this becomes even crazier and more obvious. I just want to say, don't get too excited about either side of this efficient breach conversation. We can see why they're not doing it here. I think Lucas's point carries the day. There's no earthly way this court's going to write a check for $10,000 that it thinks Lauren's client is in fact not going to use to publish. And the reason that the Lauren's client is not going to use to publish it is because you can't pay Oxford or Cambridge to publish your book. That's not how that works. And even if you could, imagine a vanity press model. That's not how you get tenure, right? That's like the AI slop end of Amazon. If you've gone and looked at books back there recently, that shit got dark real fast. Like there are no humans involved at that part of that, right? So no, not how you get promotion and tenure. So we just don't believe anybody, and that's the key factor of the case. All right, yeah, Chris.
But if author would have proved that he could have gotten royalties, he would have gotten royalties.
All right, what are royalties in this case?
What do you mean? Don't they get like 10 points on the first 100,000 of book sales or something?
Sure, but I mean, what are they in terms of our discussion? What kind of damages are royalties?
Speculative.
Speculative, and that's why you don't get them. By the way, write it down in your notes, where future earnings are speculative, courts start doing things like relying on detrimental reliance. They'll give you your out-of-pocket costs because those are certain. Even if they can't predict the future, they can at least look at the past. So that's one problem, is they're too speculative. What's the other reason, Aiden? What's that? They're consequential damages. Well done. These are textbook consequential damages, right? The idea is they didn't publish it. Your direct damages there, if a court were going with direct damages, would be something like cost of alternative performance, which is what our whole big fight between David and Lauren was, right? Is this cost of alternative performance, or is this extracting the gain from the breaching party? And we went back and forth on that. But they're not even going for alternative performance. This is something that would flow as a consequence of the breach, caused by the breach. And when we get to the most famous, not the most important, the most famous case in contract law, Hadley versus Baxendale, this is the Old English common law that defines what consequential damages are, and it describes them as damages that flow from the breach. They are not the damages of the breach. They are damages that flow from the breach. And so we assume that consequential damages don't play a huge part in this case because there's not a publisher alive that is going to guarantee you royalties. Like I guarantee you they will have said, no consequential damages. You just put that in your contract and you're generally done. All right? Cool. Great work, folks. All right, let's move on then. To a case that makes me hop up and down with rage. And let's see. Kristen, would you mind setting up PV House for me, please?
Yeah, the PV house is owned a farm with coal deposits, and
Yep.
leased premises to Garland Coal Mining that's been in for 5 years for coal mining. And it was strip coal mining, so it's taking from on the surface of the ground instead of like from underground. Garland Coal agreed to perform restorative and remedial work and the lease. And it would involve work that would likely cost around $29,000 according to the PV House's acquisition. And all covenants and contract were carried out except the remedial work at the end. And the jury considered they weighed between PV House's pushing for cost of performance, or initially they pushed for specific performance, but that doesn't work out. Cost of performance, or Garland Coal's diminution-in-value. But they ended up deciding on 5,000, which was not the diminution-in-value, 300, but also not the $25,000 cost.
Okay.
Yeah.
All right, which side do you want on this? Do you want cost of performance or do you want diminution in value? Okay, you're going to take diminution in value. Okay, well then let's go ahead and I'll have you make your case first and then I'll ask Elizabeth to knock this one out of the park.
Okay. Well, I believe that it should be value because the idea of paying $29,000, which is 5 times or more than 5 times the amount of the actual value of the land, is completely unreasonable and unreasonable economic waste, and the breach was efficient.
Okay.
We didn't really find that much coal anyways.
I mean, in a way, like this is just the same argument all over again. Look, what's another way of putting it? What are they going to do with that $29,000 check? Are they going to pay somebody to fix the back 40? Yeah. No. What are they going to do with what are they going to do with that $29,000 check? And use the word Aruba in a sentence. Right? Like, I mean, I used to actually teach this class. And I have, like, it's still up in my office. I have like the flag of Aruba, and like I whip it out and I wear it like a cape. Like they are gone. They're not gonna use this $29,000. Like they're gonna go to some gorgeous tropical islands. Like little drinks with umbrellas will be involved, and they're not gonna spend any of this money securing this alternative performance. Hey, Lauren, back on Freund. What fact would you have wanted to change if you were going to win that alternative performance argument? Like get out from under Lucas's point, like he's never going to spend the 10,000 to get it printed somewhere else.
I needed the 10,000 to finish the manuscript.
You needed it to finish the manuscript, Liam?
You just would have gone and spent $10,000.
Yeah, like imagine he dropped $10,000 and gotten promoted, like gotten the book published at another academic press and gotten it as a result. Do we think there would be this long dark night of the soul about efficient breach and like the court getting in its feelings about? No, absolutely not. What happens there is affirmed for the plaintiff, $10,000, sit down, shut up, right? That's what happens at this point. So, one point to really drive home, and I'm kind of setting you up for this, is like, yeah, but if the PV houses had spent the $29,000, I want you to see how fast this theory, this area of law just changes. Now, you might ask yourselves why they didn't. Okay. Tell me about then the alternative performance metric. What you got going for it? Right, because you're arguing not for diminution in value, she's going for diminution in value. What was the diminution in value to the property? $300, right? Because apparently the difference between a farm in this area and like a post-apocalyptic hellscape in this area is $300. I'm going to give you one further boondoggle. Based on what is the diminution in value $300? Dun. You see it under the surface. It's back from the first day of class. How are you going to tell that the diminution in value? How would you say to the court that the diminution value is $300? Oh, shit. Market value, right? Where am I going with this? Dun, 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 dun.
It's not the same as their subjective value of having their land back.
All right, now you are properly armed and armored. Kick ass. Take names.
All right, so we, the plaintiffs, want cost performance based on also the fair market value, what it would cost to have somebody else come and repair the massive holes that you put in my land by strip mining.
And not to interrupt your flow, excellent argument number one. Alternative performance is the gold standard bedrock. You see that? So just saying alternative performance is where we go with this. Tempt the court to go there. Love it. Keep going.
Also, it's like the goal of damages is to put me back in a situation where I was, if the promise had been met, the promise in the contract to fill all these holes, to repair all of this. So the only way to do that is to repair it, or at least give me enough money to pay to repair it.
All right. This is, do you keep your promise? Or what's your response to that? Your client did agree to repair it. Seems perfectly clear in the contract. Why not make your client do what they said? They agreed to it. They didn't have to. They did.
Well, the purpose of the contract was for coal mining, that was supposed to, benefit both of us. And the purpose of the contract wasn't really for, it was incidental, I believe.
Was this?
An object of the contract.
Was this incidental to the contract? Was this a sideshow to the contract?
No, part of it, the contract is for the use of my land for, like, the coal mine on it. It was my land, it was very much a part of the contract.
Right, and the way to drive this home, like not only did she agree to it, but let's say that they had said, no, we're going to leave your back 40 a post-apocalyptic hellscape. There's an apocalyptic hellscape clause. It's actually clause 17. We will make it look like Mars.
It was a conditional part of the negotiations.
Yeah, like, what are you talking about? We wouldn't have signed it if you hadn't promised. And to drive the point home, why wouldn't you have signed it if they hadn't promised to fix it? Yeah, it's a post-apocalyptic hellscape, and before, let's start getting Bambi involved. And before it was, right, exactly, okay. And before it was this beautiful thing, and what's the appropriate, what measure of the difference between the sort of Bambi bucolic framework and a post-apocalyptic hellscape, what's the appropriate, what measure are you drawing on there on your point of we wouldn't have signed it if you'd have told us you were going to turn our back 40 into Mars? Well, you are pointing to cost of performance, and you started by saying cost of performance is a fair market alternative cost of performance, which is good, but I think it obscures the issue. What's the valuation at stake here when you're saying I would have signed it if you said we will fix it? I will not sign it if you don't. What's going on here?
Is it just an objective intent of the parties in the contract?
What's an objective intent of the parties capturing?
It's expressing their subjective utility.
There it is. It's expressing their subjective utility, right? We give Your Honor, we give exactly 0 beeps about what the diminution in value on the blue book of our farm is. We demonstrated with cash on the barrelhead and cash on the barrelhead is here, by expressly negotiating, we demonstrated objectively our subjective valuation of this term. In other words, let's say then that the company had said, absolutely not, we are not going to fix the back 40, but we would still like to do this deal with you. Let's say that you actually were able to get your clients to agree to that. What would that look like?
Like, to agree to that in the initial contract?
No, you're going to be changing the contract now. You've got views on what the new clauses are going to say. And what are the new clauses going to say? If they say, nope, we're not going to fix it, we understand this is very, very valuable to you. You've just made that clear by refusing to sign it without the no fixing clause. But that's non-negotiable on behalf of our company. But we would still like to do business with you. And your story, and your response is, cool story, I'll be adding a few clauses. What will they say?
You're gonna give me X amount of money.
Yeah, like, among other things, we know that the price that they paid incorporated the cost of fixing this. If the clause hadn't been there, it would have been a different price. And then the question is, do we think that that price would have been $300 higher? We do not. Okay. What I need you to see here is this case is an easy winner back and forth, like where the framing drives everything. Could you just give me the cleanest black letter law statement of why you obviously win? And don't worry, I'm coming right back to you. Why do you obviously win? Under the black letter law, what law are we under? We're under the common law, right? We're under the restatement. And what does the restatement have to say about this?
The whole 346 is
Yep.
if it's possible and doesn't involve unreasonable economic waste, and that the diminution in value caused by the breach is the proper measure if construction completion occurs doesn't involve unreasonable economic waste.
Okay, so you just win because alternative performance would involve unreasonable economic waste. That's your key language. Elizabeth, your response is?
Not call it waste, I might have my land back, but also, like, when at the signing of the contract, you were aware that there might be this dissonance.
Right.
Between the costs, so.
You have been warned. Like you were told, right? You were told that this was a stopping point in the contract, and you don't just get to hand that out for free. Among other things, which way does this case cut? I can think of at least 2 ways. Like, now let's say this case is on the books. What does that do to the mining industry in the area? Chris?
Like Justin said, like this is just gonna they're just gonna destroy neighborhoods and just promise all this stuff and then get the coal and leave.
So one, if they don't, you can see that they are making out like bandits, right? They made a very costly promise that clearly was worth, in the subjective negotiations of the parties, as objectively written out in their contract, it is clear that they valued this performance at well above the $300 diminution in value. And so if they just get to pocket that difference, then great, they make out like bandits. Does anybody see why maybe the coal mining company should have thought this one through? Mike?
There are people who won't let them work on their land. They'll get them in higher royalties.
Yeah, like, I mean, can you imagine? Like, winning this case is what we call in classics a Pyrrhic victory, right? Pyrrhus was deemed to be an absolute genius of a general, but of course had this nasty tendency of losing way too many of his soldiers every time he fought. This is a Pyrrhic victory because you're a local attorney, right? Like, that's why you're litigating this lawsuit. You get another client, and these geniuses want to mine your client's back 40. What do you have to say to them now? Like, that's not happening. This deal is not happening because you can't be trusted to follow through on your promises, which means that efficiency cuts in a really weird way. On the one hand, you might say this is efficient breach, right? That's unreasonable waste, right? It's efficient to not put $29,000 in when that is 5 times, those are great numbers, right? This is 5 times the value of the farm and only you're gonna get a $300 increase, objective increase. But do notice, as a society, we're gonna maybe start losing future benefit and God's gonna start popping balloons left, right, and center because we're no longer able to come to an agreement because you can't be trusted to hold to non-negotiable terms. All right. Questions on PV House? Yeah, go ahead, Gracie.
Could it not be argued that these guys literally move dirt for a living? They are taking control of how deep they go, so they would be aware, and they're aware from the get-go that they're going to have to fix it.
Yeah.
So I'm not sure if there's a duty to mitigate that only appears at one point, because like they knew how they were going to go and how much it would cost to fix it, so they could have stopped at any time.
Yeah, it's like entirely self-inflicted in a lot of ways. And also key to their industrial profile, right? Like they need to be able to do this kind of exploratory mining on people's property to find out where the stuff is. So yeah, there's a real argument that this is a particularly short-sighted case for the company that wins it. Like I get it, you save $29,000, $28,700, and but you certainly scared off anybody else from believing those promises. More, yeah, go ahead.
Granted, this would have been a little bit of time, but in the notes it mentions that a boy drowned in the pits later on. So wouldn't the liability that they exposed the PV houses to far surpass the millions of dollars that the market value difference is?
Yeah, that's why we insisted on the clause, Your Honor, right? Like, I mean, at some point you just want to tell the judge, you screwed this one up. Among other things, I do want to return more questions before I get to our last issue. Aiden, yeah.
The PV houses had like fractional litigation or in the early stages of litigation, like secured a landscaping company that's going to come in and
Yep.
$25,000.
Yep.
Just like flip the place on its head.
It makes it real hard. Let's say they do that, because that's clearly the argument lurking in the wings. Kristen, you done? Let's say they do that. We're changing the facts of the case on you. Now they've already gone and they've incurred an obligation. They owe a company, which has already done the landscaping, $25,000 as a result of telling them to do it.
Then things would be different.
Things will be different, but can you still win?
I mean, I think you could probably still say that it's an unreasonable transfer.
Yeah, why?
I mean, I would like to go back to the same reasoning, like it's like still like an unbelievably disproportionate amount of money for us to be.
Yeah. Where have we seen that before? Where if a person spends way too much in securing alternative performance, the court gets real sarcastic about that. I've given you some framing examples. We haven't gotten to the case law yet, but some framing examples. Where have we seen that? Riley? Yeah, a brand new F-150 with Pokemon flashing on the sides, right? Gold rims, halogen underlighting, stuff like that, right? Like everybody can see that that's the circumstances in which I breached and you went and bought that and it cost you $100,000 and the court's going to reduce the damages to what they should have spent if they had been acting reasonably, which means I'm just going to make you opposing counsel here. What's your response to that? So she's like, no, it's still inefficient, right? Your client basically bought a gold-plated Cadillac F-150 with Pokemon on the side. And your response is? Because there's a difference between that scenario and what you posited, which is they went and got another landscaping company to do the landscaping. Open it up, Lucas.
That's what you promised in the contract. You promised.
You freaking promised that in the first place, and I'm not going and getting, I'm not getting something that's better, that's not mentioned in the contract. I'm going to get the exact damn thing. Look, if they build a hockey ring for you, that's one thing, but that's not what's going on here, right? You can imagine turning the hellscape, you're like, could be a nice bodega. But that's not what they're doing. They're not upgrading this to a ski resort. They're just doing what the contract says. And so it's a real hard one to say, yeah, you should have you did stand on your contract rights, even though the cost is so high. I think that's what you're going to, exactly what you're going to hear though. Like in answer to your question, it's a hard one for exactly the reasons that Kristen and Lucas have expressed. It's a really hard one because on the one hand, You don't want to encourage people to do dumb crap, right? By overpaying on their remedies. And among other things, your interpretation of what the amount of damages is depends, sort of gives you a sense of what's reasonable to do to prevent that damages. Like, let's say you actually believe that the damages involved were $300. Can you see how spending $25,000 to mitigate $300 worth of damages could really seem unreasonable? And so the court would be like, no, we're going to treat you as if you had acted reasonably instead of doing what you did. So but then you come back to it, you're like, well, yeah, but they did it, and this is exactly what was promised in the contract. Don't want it? Don't promise it. And it really does raise a big problem because, let me ask my final question, what do the PV houses of the world do next time? Liam.
Just ask for money instead of asking for performance.
So one, this company has really raised its costs of doing business, right? It might have been, go ahead. I thought I heard somebody. Oh, it coughed, okay. Let's see, I'm just hallucinating. It's not the first time. Yeah.
In the contract, you could establish like a agreed upon value of the land that is not what like the courts would determine. You establish that beforehand so that there's no argument whether or not like this tiny amount is there.
We'll see this at the very end. A liquidated damages provision. Remember we had that moment where somebody was like, what does liquidated damages mean? A liquidated damages provision where the parties have agreed upon the cost. And given the amount of uncertainty that Aiden's successfully raised here, even though everybody I think can feel it, that they're not going to make you pay $29,000 to fix $300 worth of damages, we get that. You agree to it as a matter of liquidated damages? I don't think there's a court in the country that'll touch it. They'll just say, look, the liquidated damages for failure to perform this are $25,000. Court will enforce it all day long and twice on Wednesdays. Justin, you had your hand up.
Oh, I was gonna say ask for the money up front or like put the money in escrow.
Right, so ask for the money up front. I love it. Put the money in escrow, right? Engage that way you've got the sort of pre-security that they're gonna follow through on this stuff. Yep.
Does this not give the court ammunition though to say, well, $29,000 for this crappy farm is preposterous, this is unreasonable,
Yeah.
even though it's objectively four corners in the contract?
Yeah, that's absolutely what they said. That's what the diminution-in-value rule did. Let's tie the silos together. The diminution-in-value rule is an objective rule of valuation. The cost of alternative performance is one of the best tests of subjective value. And if I ask you the question saying, hey, is the objective theory of contract really the driving theory of contract? You're going to go, PV House, I'm not sure that it is, among many other cases that do the same thing, right? This is the core point. This is an objective statement of their subjective preferences. And so the key insight there is Benton's, and we're just going to leave that. Yeah, Bailey.
I'm just a little confused at the end of the majority's opinion. It
Yep.
talks about how the rule as stated that they kind of like make all this happen under, that it doesn't interfere with the property owner's right to do what he will with his own, and then where that fact
Yeah.
is like either like contemplated by the parties, made principle of purpose, then they say that the measure of damages for breach would ordinarily be the cost of performance. So like,
Yeah.
couldn't you just say that this is, they did?
I think it's the extremeness of the difference that really drives it. Had this been even $1,500, that's a factor of 5, which is already crazy, right? $300 would be your diminution in value, $1,500 would be your alternative performance. I think the court's just like, is not gonna touch it. But those are the key issues. Like you heard Elizabeth lead off saying, this alternative performance is our bedrock. And you heard her closing argument, which is, in the future, I'm a property owner, and if you're gonna do that, I will not give you permission to enter into my land. And the court knows it's screwing up. They know they're damaging property owners' power to maintain what is done on their own land because the PV houses expressly contracted for it, and we're kind of having a long dark night of the soul, at least until we came up with the idea of liquidated damages. We're having this long dark night of the soul about whether or not the PV houses will actually ever enter into this kind of contract again. The court knows it's screwed up. It's just that it's going to screw up no matter what. Like, I think we can feel uncomfortable about the other path too, right? I think we're just right back to Lucas. I won't make you raise your hand, but just like in your heart of hearts, are any of you going to write a check for $29,000 to the PV houses? And if you do, are they going to fix the hellscape with it? Okay. Like, you see it? Like, and instead of thinking, oh my God, law has no meaning, you're like, okay, now I can win either side, which is the purpose of this class. All right, follow-up questions there. We got a few minutes. Yeah, Talia. Yeah, and that's a key reason why they didn't do Aiden's move, which clearly would have strengthened their case by a long shot. Did you notice, by the way, how I quietly reframed it? I said they owed the excavation company the money because I was assuming they didn't have it. And so that was their measure of damages. Like, we did secure alternative performance, but now we're owed this because you wouldn't do it, so you need to pay the amount that we owe. But that just means that the company was willing to extend credit to poor farmers, and maybe they won't even be able to do that, right? The whole thing, all this is doing is just making Elizabeth's argument stronger and stronger and stronger, saying, look, I wasn't willing to do it if you didn't sign off on this, and the fact that it was too expensive, as Gracie points out, is a you problem. You're the one that blew the holes in the back 40 and made the kid drowning pool, and so we're not gonna take that back, right?
This might be too hypothetical, but since they are farmers and the land is their way of earning an income, if they put that in there with a potential income they would have lost, would that have made any difference?
Yep, it would. But what are we gonna call the who said it? Consequential damages? Yeah, those will be consequential damages. Those will rely on some clauses we haven't seen in this lawsuit. There might be a disclaimer of consequential damages, although I will tell you, under the rule of Hadley versus Baxendale, which we will do pretty soon, it turns out consequential damages are recoverable if they are foreseeable, and by putting them into the contract, you made them foreseeable, right? Looking pretty good. If you put them in the contract, looking pretty good for consequential damages.
I guess for me, what I struggle with this is like every time you buy anything or contract for anything, it's the gamble with the universe. The coal company lost. Why wouldn't the court just enforce them losing their gamble with the universe? Like,
Yep.
Otherwise, everything falls apart.
I love this answer. I love this question because it goes to our fundamental concept of gamble of the universe. Why won't the court say you lost your bet against the universe?
Because the universe is worse if they make them pay for it.
Yeah. So economic waste, the universe is worse if they make them pay for it. NIPSCO, a kind of a NIPSCO style argument. Why else, Scott?
Is it because we're more concerned with not funding the
There it is.
houses, like vacation to Aruba?
Right? Like they lost the bet against the universe, right? But let me tell you, the PV houses did not win that hard. The PV houses did not win 5 times the sale value of their farm hard. They may have won. They didn't win like that. That's crazy talk, right? So that's the windfall language that we developed earlier, is to say, sure, they lost their bet against the universe, but also remember, we have switched jerks. We are no longer watching jerk 1. We are now, we've like, yeah, you were a jerk, you lost the case. Okay, you, I'm watching you. Don't push it. And that's where our windfall theory comes in. Okay, I gotta let you go. Great class, great participation, love it the most. We will pick up at this time next time.